And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her. I mean, which is per,
But I get the SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
What happens when a judge refuses to simply trust an arrest report? Can someone really be arrested, taken to jail, and then released because the evidence wasn't strong enough? In this video, you'll witness 3 real probable cause hearings from a Texas courtroom where every detail is challenged, every fact is questioned, and every constitutional protection is put to the test. From a DWI case dismissed over a simple smell of alcohol, to a fleeing charge that fell apart because of a poorly written police report, and an organized crime allegation with almost no evidence, these cases reveal how one judge's careful scrutiny changed the outcome. Stay until the end, because these courtroom moments show why probable cause isn't just a legal technicality, it's one of the strongest safeguards against wrongful arrests.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
And
then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank two beverages.
Just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the gyms, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk-in turn, the one-leg stand. He also noticed that I think she took off her boots for the one-leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, just an odor, not even a strong odor at that, and then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? There's no accident here. There's no. Is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her. I mean, which is per,
But I get the SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol.
This is the first major turning point in the video. Instead of accepting the officer's report at face value, the judge carefully examines whether the investigation itself was legally justified. It highlights the importance of constitutional protections during traffic stops.
Yeah, it seems that this stop occurred at 2 a.m. and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period clean when she's finished drinking, and then
alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
She still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
Yes, Judge.
Ma'am, be careful, really. Every single day.
This is one of the strongest courtroom moments. It demonstrates that even when someone is arrested, the court can reject the arrest if the legal standard for probable cause is not met.
What was he doing wrong?
The officer, he was originally traveling at an unsafe speed, exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
nothing's unsafe to me.
And then he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So
anything illegal with that?
I believe it would just be the speed limit would be the point at which the officer.
It's a conclusory statement. We need to have like a workshop on how to write ORs, man, for real. Everything in this office report is conclusory, suspicious, aloysius. Is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure,
DMs.
let's do this. I'm gonna have them, because I want to make sure if we,
This scene exposes how poor police documentation can weaken an entire criminal case. The judge insists that specific, articulable facts, not assumptions, are required under the law.
okay, so Mr. Shaw, we're back on you. So just because we do so much, I tend to forget everything, you know. You're charged with fleeing a police officer, you're facing up to 6 months in jail and a $2,000 fine. We left off because we were doing probable cause, and I had an issue because it seemed like the cause was kind of conclusory at the time. And do you have anything new?
No, Judge, and I agree with the court,
So, okay, I'm gonna find no probable cause.
dismissing the case.
Find no probable cause. Be careful when you're out there. It's hard enough as it is. Don't give anyone else the power to even bring more, you know, trouble on your life, all right?
This moment reinforces that the prosecution also has a duty to acknowledge insufficient evidence. It shows the courtroom functioning as a safeguard rather than simply approving arrests.
I have so many questions.
Yes,
I
Judge.
don't even know where to start.
Judge, my concern is, if you may, I want to just bring some, I guess, some points of argument to the court's attention. The first one, my concern is that, I mean, the 911 caller mentioned unknown parties, and then the police officer later mentions them as suspects without any type of articulable facts, believe that they are the specific people or the individuals that have taken this fuel. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the DIMS, at least under the four corners of the DIMS, allege that my client was involved with this alleged act.
I mean, remember, like, so when they start an investigation, sometimes they just don't have everything, and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul,
Yes, Judge.
and they've given a description of a tall, lanky person,
Yeah.
right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Serta remained in the U-Haul. There's no further information regarding Serta.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality? Like,
And Your
what
Honor,
can you just, does mere presence impute criminality?
Judge, and that's exactly right. Texas law says that mere presence is not enough to
Dude,
bring trouble.
I'm with you.
Oh, yes, sir.
But, so,
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have the information. We'd have to await the OR, and we don't have at this time. So-
but I'm not gonna sit here and
Yes,
hold
Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because, you know, 7102. A person commits an offense if with intent to establish, maintain, or participate in any combination or in the profits of a combination or as a member of a criminal street gang.
This is one of the most educational parts of the video. The discussion explains the difference between being present at a crime scene and actually participating in an organized criminal enterprise.
Activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS, but right now, Chief is looking at it.
And Your Honor, we could just maybe reset it for a week or so, we call the witness. and we have to decide.
He's in custody, you know, and I can't, I mean, if he was on bond, that would be one thing, but he's in custody. I'm not gonna hold him just because, you know, compounding it, Casey, is that he's got an ICE hold, so I can't give him a PR bond, you know?
I just need a little more time on it to discuss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, you know, by all means, but all right, Mr. Sird, I'm going to find that there's no probable cause to go forward in your case.
This is arguably the emotional climax of the video. The judge prioritizes individual liberty over speculation, reinforcing that people cannot remain jailed while the prosecution searches for evidence.
February 24th, 2025. These hearings underscore why probable cause determinations are such a vital safeguard in our justice system. When someone is arrested without a warrant, they are immediately deprived of their freedom, potentially based only on an officer's word. The probable cause hearing is often the first meaningful opportunity to test whether that arrest was truly supported by evidence that can withstand judicial scrutiny. Judges like Judge Fleischer, who carefully examine the evidence rather than simply rubber stamp the arrest, help ensure that constitutional protections are meaningful in practice and reinforce the principle that government power must be checked. When judges find that an arrest was conducted without probable cause, they not only protect the individual accused, but also strengthen public confidence in the court's commitment to fairness.
This closing message ties all three cases together. It leaves viewers with the central lesson that the justice system works best when judges actively protect constitutional rights rather than treating probable cause hearings as a formality.